Leasing property is a common part of both business and personal life. Whether you're renting a flat, a car, or even equipment, you enter into a contract of lease. In this agreement, the lessor gives the lessee the right to use and enjoy a property temporarily in exchange for rent. The property can be movable, like a vehicle, or immovable, like a house. It's important to note that a lease can be verbal or written, but having a written lease is always safer, as it provides clear proof of the agreement and is easier to enforce against third parties. Sometimes the lessee may even sublet the property to someone else, called a sublessee, if the original lease allows it. The law of lease sets out the basic rules, rights, and duties for both parties, ensuring fair use and protection for everyone involved. Leases come in several forms, each with its own rules and duration. A fixed-term lease runs for a set period, like 1 year, and ends automatically unless renewed. Tenancy will last as long as both parties agree, ending when either wants out or if one party dies. Periodic leases such as month-month agreements continue indefinitely until proper notice is given. There are also hybrid leases, which combine features of fixed and periodic leases, allowing early termination with notice. For a lease to be valid, there must be an agreement on rent, which is usually paid in money, though farm leases may allow payment in produce. The property being leased must be clearly identified and the lessee's use must match the agreed purpose. These details help prevent disputes and clarify each party's expectations. Lessees enjoy important rights under the law. Once they take possession, they cannot be evicted without due process, and their right to use the property is protected, even if the property is sold to a new owner. This is known as the Huurgaat rule, meaning the lease survives a sale. Long-term lessees, especially those with leases over 10 years, have extra protection if their lease is registered against the property's title deed. Short-term lessees are protected as long as they occupy the property. Lessees can also claim compensation for necessary or useful improvements they make, but not for luxury upgrades. These protections ensure that tenants can use the property as agreed without fear of sudden eviction or unfair treatment, and that their investments in the property are recognized. Both lessors and lessees have clear duties to ensure a fair and functional lease relationship. The lessor must deliver the property in a usable condition, maintain it, avoid disturbing the lessee's enjoyment, protect against eviction by third parties, and pay rates and taxes unless agreed otherwise. If the lessor fails, the lessee can seek remedies like specific performance, damages, or even cancel the lease. On the other hand, the lessee must pay rent on time, care for the property, avoid unauthorized changes, and return the property in good condition. If the lessee defaults, the lessor can claim unpaid rent, damages, or seek eviction. These mutual duties and remedies help balance the interests of both parties and provide solutions if things go wrong. Beyond common law, several statutes further regulate leases. The Rental Housing Act protects tenants from unfair treatment and requires lessors to provide receipts and invest deposits properly. The Consumer Protection Act limits most leases to 2 years, unless longer terms benefit the lessee, and allows early cancellation with notice. Formalities in respect of Leases of Land Act confirms that leases need not be in writing to be valid, but written agreements are strongly recommended for proof and enforcement. In summary, the law of lease sets out clear rules for agreements, types of leases, rights and duties, and remedies for breach. Understanding these principles helps both lessors and lessees protect their interests and resolve disputes effectively.